It's 2025 and a new year means brand new opportunities. And for a lot of you out there, I know you've been thinking about one thing over the holidays, and that is starting your own business. But you have so many questions like how do I get started? How do I come up with a brand? How do I even sell stuff to people? And what am I even going to sell? Now take a deep breath. Shopify has got you. Shopify makes it simple to create your brand, open for business, and get your first sale. And you can get your store up and running easily with thousands of customizable templates. You don't have to be a coding nerd or a design geek to get this done. All you need to do is drag and drop. Shopify also helps with the details like shipping, taxes, and payments from one single dashboard, so you can focus on the important stuff, like growing your business. Established in 2025 has a nice ring to it, doesn't it? Sign up for your $1 per month trial period at shopify.com/truecrime, all lowercase. Go to shopify.com/truecrime to start selling with Shopify today. Shopify.com/truecrime.
I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my judicious co-host, Brett.
Hello, Alice. That is so false for so many reasons, but I'm always happy to have your kind words about me, even when they're not really about me.
They're not about you at all, Brett, because today's episode is not about Brett. Today's episode is actually about a really exciting guest. I know you guys are going to love hearing from him. We have a real live judge here with us. We have Judge Trevor McFadden. And the reason this is so exciting is we try to explain to you legal opinions, why things happen from the parties' perspectives. But at the end of the day, and you guys know this, the judge is the arbiter for these types of controversies. And it's always helpful to know how a judge, thinks about cases and how they even reach the position that they're in. So please join me in welcoming Judge McFadden.
Thank you so much, Alice and Brett. It's really a pleasure to be with you all. We've been friends for many years, and it's really exciting to be on the show with you.
Yeah, and Judge McFadden, he's not just a judge. He's a federal district judge for the District of Columbia, which is one of the, if not the most prestigious district courts you can sit on. I'll say all this so he doesn't have to.
Gee,
yeah,
Brett, I hear my friends in districts around the country pushing back on this and kind of.
I'm sure they will, but I mean, the fact of the matter is, DDC, EDVA, and the Southern District of New York are sort of a cut above, I think, and so it really is a great honor to have you joining us. And we're really excited to talk about really anything you want to talk about because you're the judge. So we just need to shut up and do whatever you say.
Thanks, Brett. I'm not sure about cut above. I know I am tremendously privileged to be on this court, and it does have a really unique docket, largely driven by the fact that, of course, we're in the federal government is headquartered in our district. And so unlike most districts where on the civil docket, you'll have really a vast range of parties, on the civil docket here in DC, the federal government is almost always the defendant, which is a really interesting reversal, of course, from the criminal side, which, as you all know, the federal government is always the plaintiff in federal court, but that we have the federal government being usually the defendant in civil cases. And as a result, a lot of the most interesting and kind of pressing questions about the metes and bounds of the executive branch authority and what the administration of the day is doing get tested in our courthouse. And that's just been such a privilege to get to be part of that process.
That sounds amazing, Judge McFadden. And, we have a lot of listeners. We hear from a lot of our listeners who are studying law or who are paralegals who are kind of just getting started in their legal career. And so for them to get an idea of how you've ended up where you are on this district court, can you give us just a quick background? Did you even know that you wanted to go to law school and then kind of the steps that led you to where you are today?
Sure. So in many ways, I'm a little boy who wanted to be a police officer who never really grew out of that. But I had this love of public service and of the law really my whole life. As I became a teenager, several relatives told me that, gee, you should think about becoming a lawyer. I think that's because I argued a lot. In retrospect, I'm not sure that was a compliment, but I took it to heart. And so actually thought I wanted to be a lawyer by the time I was looking at college. And indeed, I went through college, did kind of a pre-law track, took the LSAT, was preparing to go to law school, and several of my mentors encouraged me to take time off before going to law school. And as I thought about what I might do, kind of being a police officer came back. So I was, in fact, a Fairfax County police officer. Fairfax County is just across the river here in Northern Virginia. I continued working as a deputy sheriff part-time in law school and for a number of years thereafter. But that experience in the criminal justice system and law enforcement really made me very interested in doing what Brett continues to do, what you both have spent years doing, being a federal prosecutor. And so after law school, I clerked for a federal judge and then spent a bit over 5 years both working in what we call Main Justice, the Department of Justice headquarters, but then also as an AUSA here in Washington, D.C. I spent some time at a law firm then doing white collar work, and then came back into the beginning of the Trump administration. I was a political appointee in the Justice Department, where I got to work with Brett, and then I got appointed to the district court here shortly after that.
And one of my interesting jobs when I was at Main Justice is I would get to take people who'd been nominated to be judges around to meet various people in the Senate and the House. And in your case, the delegate from Washington, D.C., because Washington, D.C. is not a state, so it doesn't have a senator or a House member, but Eleanor Holmes Norton, who has been it for decades. It was really interesting to meet her and sit down with her and sort of, the fun part about doing that is I got to just watch. It was probably very stressful for you talking with her and answering her questions.
Yes.
And she was trying to determine, whether she wanted to support your nomination or whatnot. But no, it was a lot of fun and it was a joy, getting to meet you. And I'm so glad that you agreed to take some time doing your obviously very important work to sit down and talk with us about what we think are really interesting issues. And I think people out there will think are very interesting issues. But once again, this may be because we're big nerds, but that's fine because people who listen to this show are also big nerds with us. So we're happy about it.
Oh, well, count me in the nerd class. And yeah, I'm excited about this topic. I think it's really fascinating and something that's somewhat of a issue that we wouldn't have been talking about this 5 years ago or 7 years ago anyway. It's a relatively newly hot topic. And so I think especially important for people to understand what is happening and how it impacts them.
Yeah. And let's, enough chit chat, Brett. Geez, let's dive right in, because the topic that Judge McFadden is talking about right now is the Supreme Court's emergency docket. And this falls right in line with a lot of our previous episodes. You guys know that we've been trying to give you kind of correcting misconceptions that are the clickbait headlines that you may see about Supreme Court opinions. And ultimately, there are opinions you can go read, but there's a lot more to the Supreme Court and how the Supreme Court kind of metes out decisions in other ways. And one of those ways is through the emergency docket, which has gotten a lot of press recently of some hot policies that have gone through this system. So, Judge McFadden, we'd love for you to kind of talk about your experience about what exactly is the emergency docket and why has it come onto like the public radar? Why have the masses paid attention to something that in the past has been pretty boring?
Sure. And perhaps it's easiest to describe the emergency docket by stepping back and saying what it's not. The typical case that reaches the Supreme Court is the culmination of several years of quite possibly a trial in a district court or a federal district court or state trial court that gets appealed up to if it's a federal case, up to one of the federal courts of appeals. Perhaps if it's on the state side, it goes to the state Supreme Court. And from there, the losing party can seek a writ of certiorari, and that is basically asking the Supreme Court to hear the case. And if the Supreme Court grants that writ, which, as you both know, is actually quite rare, only about 1% of the cases that seek cert actually have cert granted, it would then go up to the U.S. Supreme Court for full briefing and argument. And, sometime a number of months later, the Supreme Court issues a full opinion on the merits. So as I say, that process typically takes years from the inception of the case up through a resolution by the Supreme Court. And even in the Supreme Court, it's probably about a year from the time the Supreme Court grants certiorari until the time it's finally decided. And so, the great and biggest cases we know and recognize, Brown v. Board of Education, the Heller case from DC on the Second Amendment, the Dobbs case that happened just very recently, those are all cases that have progressed in that normal way. But there are some times where there's an emergency where a party cannot wait for years to get the Supreme Court to hear and decide the case. And this is not a new thing. You can imagine for a long-standing example of this would be capital cases where a death row inmate is facing execution and is seeking an immediate action, an immediate stay from the Supreme Court. So that would be a very common example of an emergency docket stay. But that happens elsewhere, and it, especially in recent years, happens in response to presidential or executive orders where the executive branch has directed for something to happen or not to happen that has immediate impact on people. And according to the plaintiffs, may well be violating their constitutional rights. And they seek emergency relief, first from a federal district court, and depending on the resolution there in the lower courts, potentially ultimately from the U.S. Supreme Court. And so unlike that lengthy process, I described that as the normal cert docket, the emergency docket can be decided in a matter of days or weeks. There'll be an emergency request to the Supreme Court. The Supreme Court can decide whether or not it's even worth hearing from the other side. And if, in fact, it decides to consider the request for emergency relief, there would be very rapid briefing. Almost never would you see oral argument. And typically, there would be a short order, either granting the relief or denying the relief, sometimes accompanied by what we call a per curiam opinion, an opinion for the court. Sometimes you also would see dissents or concurrences from the justices.
Right? You've been referring to it as the emergency docket, but there's another name for it, right? The shadow,
that's right.
The shadow
docket.
Which I mean, everything you've described sounds pretty standard and non-controversial. You have sort of something that needs
boring,
to be rolled on quickly. Boring, yeah. It's like you gotta have something rolled on quickly. So you file something, you get it rolled on quickly, you either win or you lose, and then you go on. But the shadow docket sounds much, it's like from Mordor, right? Like a shadow is rising in the Supreme Court. So why is it called the shadow docket? And why is that process that you described, why is it controversial?
Yeah. So Professor Will Bode out of Chicago coined this term, the shadow docket, for an article he wrote probably about 6 or 7 years ago. And my understanding is he actually had referred to it in his title as, thoughts on the emergency docket or whatever. And one of his reviewers said, that's a really boring title. You need to come up with something a little snappier, something that's going to get people to read it. And so he came up with the term shadow docket. And at the time, my understanding is by using that term, he meant this is a docket that people do not pay a lot of attention to. It's, we tend to focus, as I say, on the merits dockets, the Obergefells, the Dobbs, the Brown v. Boards, those major normal cases. But he said, hey, we should be paying attention to what's happening here on the emergency docket. And so I think he used that term, not necessarily pejoratively, but more to suggest that people aren't aware of the emergency docket. That has certainly, some people have really run with the term shadow docket and tried to use it, I think, more pejoratively, suggesting that there is something a little suspicious, shadowy, untoward about what the court is doing there. And in large part because there have been some major cases over the last probably 5 years that have been considered, sometimes ultimately decided on the emergency docket. Just to name a few, the travel ban, Trump's travel ban, was initially an emergency docket case. Border wall funding, Trump's border wall, those were also considered on the emergency docket. During COVID, some of the ended up really important COVID cases involving religious liberty were decided entirely on the emergency docket. And the CDC eviction moratorium, Texas SB 8. So yeah, you've seen a lot of high profile cases on the emergency docket recently, which I think some commentators have looked to kind of call into question not only the outcome in those cases, but also the process. And the shadow docket term has been useful, I think, there.
Hey, Judge McFadden, you mentioned some of the COVID cases, the ones you mentioned earlier, yes, those were hot topic, but you listed the last kind of 2 or 3 cases to be in the COVID era. And that's really interesting because I do think COVID changed a lot about how we access the courts and also changed the way in which the general public sees how courts work. And what about these COVID cases made their way onto the shadow docket versus the normal merits? Was there anything about kind of these cases that drew more attention to this particular docket that the general public would find interesting?
Yeah. So I think, in some ways it makes sense, right? This is an emergency docket. It's responding to an emergency. And of course, a lot of the COVID restrictions were also implemented in what I think, we can all agree were an emergency situation. And so both at the federal level and at the state level, you had governors and then the president and the executive branch acting rather than through what you kind of expect, passing laws, notice and comment, what have you. They acted very rapidly and in some ways with sweeping consequences. And at the state level, some of the restrictions that got the most play at the Supreme Court involved restrictions that either directly or explicitly or indirectly really impacted people's ability to exercise their freedom of religion. And so one of the most famous or important cases of those is called the Diocese of Brooklyn. This is where the then governor of New York, Governor Cuomo, had basically redlined in New York areas that he called were hotspots, COVID hotspots, that just so happened to, with shocking regularity, also hit houses of worship, churches and synagogues, and said you cannot have large gatherings in those hotspots in those areas, public gatherings. And that had the effect of basically shutting down a number of churches and synagogues in New York. And so the Catholic Diocese of Brooklyn and several synagogues sued in federal district court there in New York. They were seeking emergency relief. That relief was denied. They went up to the Second Circuit, the Court of Appeals in New York, the federal Court of Appeals there. They were also denied. And then they went up to the US Supreme Court seeking emergency relief. And after getting rapid briefing from both sides, the Supreme Court did stay the governor's order. And somewhat unusually, even for the emergency docket, there was a multi-page opinion from the Supreme Court explaining why they were instituting this stay and explaining the importance of protecting people's constitutional rights and here their First Amendment rights, even in the context of the COVID pandemic.
Let me ask you this. Is that binding precedent?
That is a really important question, Brett. And just to back up for your viewers, to explain why that's important, I want you to think back with me to the merits docket, the kind of the typical Supreme Court cases. We don't care about those typically so much because of the actual parties involved. Again, think about Heller versus District of Columbia, the celebrated Second Amendment case. We didn't care about that case because we're wondering whether Mr. Heller is going to be allowed to carry a handgun in DC going forward. We care about it because the Supreme Court's decision on that constitutional issue sets precedent for all of us lower courts in all of these similar cases that can crop up around the country. And so that the Supreme Court's, the precedential effect of Supreme Court cases really is a hugely significant part of what the Supreme Court does on the merits docket. And so I think that I began asking myself, because I had some of these cases, gee, I see the Supreme Court making these decisions on the emergency docket. Am I bound by them? And what, if any, implications do those decisions have for me? And interestingly, there was almost no literature on this, very little case law on this. But as I thought through it and began studying the issue, I became convinced that at least in the type of circumstance in like Diocese of Brooklyn, where you do have an opinion reflecting the ruling of the majority on a legal issue, that is binding on us lower courts. And I think the Supreme Court has now made that clear as well, and specifically in Diocese of Brooklyn in a couple of different ways. First, there were several similar cases pending in front of the Supreme Court at the time. And after the Supreme Court decided Diocese of Brooklyn, it summarily reversed the lower court opinions and told them to reconsider their decisions in light of the Diocese of Brooklyn ruling. That would really only make sense in my mind if the Supreme Court thought this was a binding ruling. And then to put an exclamation point on it, the Supreme Court went on to consider over the following months several other cases emanating out of California, where Governor Newsom was also essentially violating people's First Amendment rights by really instituting very stringent rules about who can gather for worship when. And the Supreme Court repeatedly struck down those gubernatorial orders, citing to Diocese of Brooklyn and the reasoning there. So, yeah, I think at least where you have this grant of a stay and done with some sort of reasoning that we can apply in other courts in similar cases, that the lower courts are bound by those rulings and need to carefully look to the Supreme Court decisions there.
So with that said, we've talked about how people pay a lot of attention to the merits docket because it has wide-ranging implications from the Supreme Court. It sounds like that same effect can be extended to the emergency docket as well. And so do we have any metrics, or do you know any metrics as to how many cases do you have a better chance of making it through on the emergency docket than, say, the merits docket? Because you had said, only 1% of cases are granted cert. Is there any teeth to the fact that the shadow docket or the emergency docket is being used more now than maybe it historically had been? And kind of what is the practical effect of that? Is that good? Is that bad? Will we see an increase in use of it if there is an increase already?
Yeah. So I hesitate a little bit to draw normative conclusions, but I think you can say pretty comfortably that there has been an increase in these emergency docket stays. I have not counted them up personally, but I've seen a few different calculations of these. One said that from 2001 to 2016, there were only 4 emergency stays granted by the Supreme Court. And then from 2016 to 2021, you had 28 grants just in that 5-year period. Steve Vladeck, a law professor in Texas, I think did a bit more exhaustive, or maybe had a broader definition for what counts as an emergency docket stay. He said that on average, you'd see about 5 stays from the Supreme Court in the years 2005 to 2013, about 10 stays per term from 2013 and 2018, and then 18 stays per term from 2018 to 2021. So I think it's pretty clear that there has been an uptick. I would say, I think litigants who are hoping to get a quick consideration from the Supreme Court and think they can short circuit the normal cert process, by saying this is an emergency and going for the emergency docket instead are probably going to be disappointed. It looks to me like the vast majority of these cases have involved the federal government, often as the party seeking a stay. In other words, a lower court has prohibited the executive branch from implementing an executive order, and the Supreme Court and the Justice Department has sought emergency relief from the Supreme Court. And so I think those cases make up a lot of these recent shadow docket or emergency docket stays. I think these church cases I mentioned and the COVID cases are a bit of an aberration there because of all of the restrictions coming from at the state level during COVID. You saw a number of those cases actually being brought by churches that were not getting relief in lower courts and sought emergency relief from the Supreme Court. But in general, you're seeing those involving executive decisions from an appeal from the Justice Department.
So explain something to me, because I'm a little confused about why this is a big deal at all. And let me sort of explain that. And for people out there who are listening who maybe aren't as familiar with the way some of this stuff works, we've been talking about stays. And Judge McFadden, correct me if I get any of this wrong. But essentially, certain things can happen. The governor or the president might issue an executive order, or there might be a law that's passed. I mean, imagine, there's a law that's passed that says people can no longer go to church. We're going to make going to church illegal. And somebody challenges that law and they want to seek a stay, an emergency relief, because they want to go to church on Sunday. And there's no way the case is going to be done by Sunday. So the judge puts in the stay, sort of an injunction or whatever. And maybe that gets appealed, and then maybe the appeals court stays that lower court's order, and that gets appealed up to the Supreme Court. All of this is kind of temporary, right? It's all temporary stuff. We're sort of temporarily putting something aside until we have time to consider it fully on the merits. And isn't that what is ordinarily happening here, that it is an emergency docket because it's an emergency, but it's not necessarily the final word on these issues? Or does it tend to be the final word on the issue? And is that sort of what people are concerned about? It's short-circuiting the longer process for a quicker process with maybe less detailed briefing or whatever all the shortcomings would be. But isn't ordinarily this more of a temporary relief thing than a permanent relief thing?
Yeah, I think that's an important point, Brett. And it is certainly true. You see administrative stays issued often by a single justice, just kind of trying to freeze things until the Supreme Court, the full Supreme Court, can consider the matter. And so, an example of that just from quite recently involved one of my cases with former President Trump's tax returns, where that the case had gone from me to the DC Circuit. And we both, I believed that Congress was entitled under the law to receiving the president's tax returns. The DC Circuit agreed. And so Mr. Trump sought an emergency stay from the U.S. Supreme Court. Chief Justice Roberts, who is our circuit justice, stayed the decision to give time for the full Supreme Court to decide. And then that stay was dissolved, I believe, just earlier this month, meaning the Supreme Court decided we're not going to hear the case, and the executive branch could go ahead and turn over those tax returns to the House. And so a couple points there. A, that was an administrative stay, but you can also see, to your point, the importance of, if they didn't grant a stay, the horse was going to be out of the barn, right? Once the tax returns go over to the House and the House publishes them, it's too late for Mr. Trump to get any relief, any meaningful relief. And that is true with a lot of these. But I think it is true that a number of these cases have ended up being the essentially the final decision, in large part because, as I was saying, this is emergency relief reacting to an emergency executive order. And so the executive order was also only expected to be temporary. And frankly, it will not, by the time it would go through the normal process, those years that you and I were talking about at the outset, from a case beginning until it gets to the Supreme Court, there would be no emergency anymore. An example of that from just this last summer, and also from my court, although one of my colleagues, was the CDC eviction moratorium, where you all may have followed this. Initially, Congress during COVID had said prohibited any evictions until a date certain. Congress failed to extend it, and the president purported to unilaterally extend that moratorium. Some realtors actually sued in my court in front of Judge Friedrich. She said what the president had done was illegal, that he didn't have the authority to unilaterally extend this eviction moratorium. And that went up to the Supreme Court. And after some back and forth, ultimately the Supreme Court agreed. They said, if we're going to prohibit all evictions nationwide, that's something Congress needs to decide. That's not something that the Constitution allows the president to unilaterally decide. And so that's an example there, Brett, of while it was all happening on the emergency docket, that it resolved the case because I think that given in the opinion that accompanied that emergency order, the Supreme Court made pretty clear what it believed the law would be. And as I say, I think that would bind these lower courts and was certainly strongly indicative of what the Supreme Court would do when it got to the merits. But more to the point, 3 years from now or whatever, when that case ultimately would have come up on the merits, the moratorium would have been long since gone. And so I think as a result of these emergencies and emergency orders coming from the executive branch and from governors, these decisions are often kind of the final decision that we're going to get, and they come up on the emergency docket. But note that if the Supreme Court had not acted, they basically would avoid or evade review, right? Because by the time in the normal course, they could come up to the Supreme Court, the emergency would be done, the order would have expired, and the person's constitutional rights would have been violated without any real vindication.
So it's really not that much different than just a preliminary injunction type situation in a lower court, right? Where when a lower court issues a preliminary injunction of a law, for those of you who don't know, I mean, basically a law gets passed, you say it violates your constitutional rights, you can get it enjoined, so the court says you can't enforce that law. Preliminary injunction, you have to show your likelihood to succeed on the merits. And a lot of times, if you get the preliminary injunction, the issue just sort of goes away because everybody understands this is decided. So is that a good analogy between those two things?
Absolutely. And I think that's an important point because, as you suggest, us lower courts, we don't like to have to move at, speed of light. We like to be able to deliberate and to have full briefing and full argumentation and what have you. But that is not a luxury we always have. And these preliminary injunctions, including emergency preliminary injunctions, are often decided by the federal circuits on an expedited time frame, quite possibly without any argument, and they would have binding effect in the circuit and on the lower courts. So I think, to your point about whether this is something really odd going on, it's actually not that different from what we see quite frequently happening in the lower courts, simply because the circumstances require quick decisions.
That's a really great point. I think a huge takeaway that often gets lost in, the headlines is what you said, that this type of docket exists in all courts, and it exists because justice requires it, because of the evading review portion that you mentioned, that there actually is no justice if there's not a swift way to deal with kind of these immediate harms that cannot be reversed. So that's incredibly helpful. Before I have a very important question, before I change the topic, is there anything else that you'd like to add on this? We have learned so much about the emergency docket and kind of what's moved through it and what the purpose of it is. But is there anything else you'd like to add about it?
Yeah. So I guess maybe 2 points. I think it's going to be interesting to watch how the court continues to deal with the emergency docket in the years to come, because obviously emergencies are not going away, but there has been this spike of important and high profile cases that are being decided on the emergency docket. And I'm certainly not a justice and don't pretend to speak for them, but I can't imagine that they love deciding important cases within a matter of days or weeks. They are a deliberative collegial body that is known for high quality work, not necessarily efficiency. If you're looking for efficiency, you should come to one judge, come to a district judge. We can make decisions quickly. We're going to do our best to try to get it right, but we can move quickly. By design and naturally, as you move up and involve more justices and more deliberation, it's harder to make these decisions quickly. And so I think the Supreme Court is wrestling with a recognized need by all sides for a decision quickly, with the impact, the import that a decision by the Supreme Court carries, and a desire to get it right and to be able to explain what they're doing and why they're doing it. And so interestingly, just within the last year or two, I think you're seeing the Supreme Court, when they can, try to move, instead of on this making a decision on the emergency docket in a matter of weeks, rather instituting one of these administrative stays that I mentioned earlier, and then looking to expedite the case onto a merits docket where they can decide the case with oral argument, with full briefing in a matter of a few months rather than in a year. And, there certainly are going to be some cases where that's not possible and not practical. But you saw them do that with the SB 8 case, the Texas abortion statute back in, I guess that was 2021. You saw them do that with the National Federal and Independent Businesses versus Department of Labor. That's the corporate vaccine mandate. That was just earlier in 2022. In both of those cases, they arose on the emergency docket, but the Supreme Court shunted them onto the merits docket, but on an expedited time frame. And I don't think that's not a panacea, and not all cases can be resolved that way. But I think it'll be interesting to see how the court continues to wrestle with the need for efficiency, with the need for a thoughtful opinion that gives full consideration to the merits on these pressing cases.
Thank you so much for that insight. I really do mean that, because it's helpful to know these processes, and also, you live and breathe it on a daily basis, not only in your own court, but your cases that ultimately end up at the Supreme Court. So thank you for your insights on these. Now, my very, very important question is, we have a lot of practitioners who listen to the show, and we also have a lot of people who just enjoy watching trials on TV. And you are a trial judge, which means you get to see people in your courtroom. What is the strangest or funniest thing you've seen in your courtroom? Anonymizing it, of course.
Man, strangest or funniest thing I've seen in my courtroom. I've not had anybody who's a cat. There have been no cat appearances on my Zoom hearings. So,
too bad.
Have you had any sovereign citizens? We talk about sovereign citizens on the show sometimes.
I have had a couple sovereign citizens. Actually, they're both pending cases, so I don't think I better talk about them. But yes, I've had a couple sovereign citizen cases.
So let me ask you this: so how many judges are on the DC?
We have 15 active judges and about 7 senior judges, who I'm just so thankful for. These senior judges, as you two know, these are judges who are eligible to retire on full salary, but rather than kicking off their shoes and going for long walks on the beach, they continue working, serving the people of our country essentially for free, given that they would be getting their salary regardless. So yeah, we're immeasurably helped by them.
So you got a lot of judges, a lot of different backgrounds, appointed by different presidents of different parties. And, one thing that we run into sometimes that I think's really dangerous, frankly, is a lot of people, the country's very politicized now, as you well know, and a lot of people think judges are just political actors. They're political appointees for life, and They forever serve at the behest of the president who appointed them, and they're Republicans, they're Democrats, and that's just the way it is. In your experience, given all those different people you've served with, what do you think about that, and what would you say to people who make that claim?
Yeah, I've been tremendously honored to get to serve with my colleagues here in the federal courthouse here in DC, as you say, colleagues from a number of presidential administrations. One of our senior judges was actually appointed by President Reagan, and we have judges serving from every following administration up to the current ones. And it's just a real joy to work with them and, to a person, thoughtful and intelligent individuals really trying to do their best by the law. To give one example of, or kind of counterexample to the narrative of Republican appointees will vote one way, Democratic appointees will vote another. Think back to my only opportunity thus far to sit as part of a 3-judge district court. You two are aware there's a unusual provision in the federal code that allows for redistricting challenges to go in front of 3 judges on the district court and then for an immediate appeal directly to the Supreme Court. And this case, Castanon, was brought by DC residents claiming that under the district clause of the Constitution, Congress has the authority to grant congressmen and senators to the District of Columbia, and under the Equal Protection Clause, they must do so. And that case was heard by 2 Obama appointees along with me. We all 3 agreed that their reading of the Constitution was just incorrect and unanimously denied the case. That they then appealed to the Supreme Court. As I said, you have the right under this to appeal to the Supreme Court, and the Supreme Court summarily and unanimously affirmed us. And so that's just an example of, a very potentially controversial and impactful and political case where appointees, both in my court and the Supreme Court, unanimously agreed on the law. And it was just really a wonderful experience to get to work with 2 colleagues rather than working myself, which is the norm, of course, of the trial court, but to decide that case. The Donald Trump's tax return case I mentioned a few moments ago, that's another case where, despite the incredible political variance there, my opinion was affirmed by the DC Circuit by judges from both political parties. It was an en banc petition was summarily denied. Again, not one judge from either political party did not disagreeing with that, and then went up to the Supreme Court, where the Supreme Court denied cert, again without any noted dissents. So, a couple very sensitive cases that I've seen where I think you've seen judges who've been appointed by presidents of both parties unanimously agreeing on the law and trying to apply it regardless of their personal preferences or predilections.
Well, thank you for your service, because you haven't really talked about this, but being a judge is kind of the ultimate public service, especially on the federal courts. It's for life, and you are serving the public in a very important way. So thank you for doing that for our country, but also for taking the time to speak to us. You absolutely do not have to speak to peons like us now that you have life appointment. Really. It's the greater service is talking to
peons. I completely disagree with that, but it's such a privilege to be with you both.
Well, I'm cognizant that we are reaching an hour of your time, and your time is very valuable. So I don't want to keep you longer. I know that our listeners would love to have you back anytime to talk about just about any topic ever. There's so much still to cover, but I want to be respectful of your time, and just to thank you so much for taking the time to educate our listeners. We say this a lot. We think it's incredibly important for the average person, not just the lawyer, to understand how our judicial system works, how our legal system works, because we all live within it, and we have to have buy-in and understanding of it for it to work properly. So thanks for being part of that education process.
My pleasure. What you're doing is really important. The justice system and the courts do have an important role in our nation's constitutional fabric. And it's really important that people understand what's happening in the courts and have an opportunity to be heard and participate in that. I just make a plug for jury service, by the way. I think that's actually one of the, other than the military, probably the most obvious way in my mind that someone can serve the country, and that's by serving on a federal or state jury. And I'll tell you, I've had so many jurors who have admitted to me after the trial that they were kind of looking for excuses, reasons to get out of it at the outset, but were really thankful that they got to participate. I am sure both of you as prosecutors have heard similar stories, but I think that's a wonderful way to participate in our justice system.
Absolutely. We love the jury system too. And so thanks for that plug, because unlike the military, even those of us who are not fit can serve that way. And so it's fantastic. Well, thank you so much for being here with us. We really appreciate your time. And do you want any last words before we sign off?
No, happy holidays to you all. Thanks for having me.
Thank you so much. We are so glad to have the wonderful Judge McFadden join us today. We thank him for his time, and we thank all of you guys for making both of our podcasts possible. And until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs.
Woo!
You
Good
did
job.
it. That was awesome. Thank you.
That was fun. Can you see my little photo bombers go by?
did.
Oh, that was
We did.
fantastic. I wanted them to be part of it.
Yeah, just invite them in.
They finished up with school yesterday, so I did take your kids to work today.
Yeah,
went
there
to
you go.
the,
We know
Natural
a lot
History
about that.
Museum earlier today.
Yeah.
Oh, that sounds awesome. Yeah,
That's
okay.
great.